Training points begin.
All right, looks like prosecution is ready to go. Defense, ready to go? Excellent. We'll bring our judges in just a moment and we'll get started. All right. Hello. Thank you to everyone watching. We appreciate you being here. Congratulations to our two final round teams. We're going to go ahead and get started for our second annual championship round of the MockOn Tournament of Champions. Before we get started, we have a couple excellent final round panelists joining us this evening, and we wanted to take a moment to introduce them all to you. They're incredibly accomplished figures in the mock trial community And we are thrilled to be having them with us. So Bennett, if you could come on screen and join me in introducing our final round panel.
Hi, everyone. I'll introduce our first judge tonight. Our first judge tonight is Sue Johnson. Sue, if you could turn on your camera. Sue Johnson is the forensics program director at Patrick Henry College, where she oversees the mock trial, moot court, and civic debate programs. Under Sue's leadership, Patrick Henry's forensics program has become the most successful in the entire country. Their moot court written and oral advocacy programs are both ranked first in the nation. Before joining Patrick Henry, Sue worked as the state coordinator for the Carolina Center for Civic Education, which runs the statewide high school mock trial program in the state of North Carolina. Sue has authored dozens of mock trial cases at both the high school and collegiate levels, and she currently serves on the board of directors for both the American Mock Trial Association and the National High School Mock Trial Competition. Most recently, Sue coached not one, but two Patrick Henry mock trial teams to fourth place and honorable mention finishes at the American Mock Trial Association's 37th annual national championship tournament this past April.
Thank you so much for joining us, Sue. Next, we have Sam Jahangir. Sam Jahangir is an attorney at Jenner & Block in Chicago, Illinois, where he's worked since 2016. He received his JD from the University of Chicago Law School in 2016, where he participated in the Edwin F. Mandel Legal Aid Clinic Civil Rights and Police Accountability Project, received the Thomas R. Mulroy Prize for Excellence in Appellate Advocacy and Oral Argument, and was the captain of the team that won the 2015 Saul Lefkowitz Moot Court competition. He competed for Northwestern mock trial as an undergraduate, but joined their crosstown rivals after graduation and has served as the head coach of the University of Chicago's undergraduate mock trial team since 2015. He has led U Chicago to several top 10 finishes during his tenure as a head coach. And this April, he coached the team that finished as runner-ups at the 37th annual Mock Trial Association National Championship. Sam is a member of the American Mock Trial Association's board of directors, and he designed the tabulation system that you all use this weekend from scratch. Thank you so much for being here with us, Sam.
Travis Harper. Travis is a rising senior at Harvard University, where 2 months ago, he captained his team to victory at the American Mock Trial Association's 37th annual national championship. In his 3 years competing for Harvard, Travis has won 3 All-American awards, which is the highest individual honor in college mock trial. At the most recent national championship, not only did Travis win 2 of those All-American awards, but he was the only attorney in the entire country to win an attorney award with a perfect 30 ranks. He isn't just a talented attorney. One of those 3 All-American awards is for his outstanding portrayal of an emotional witness, a performance that was featured in the championship round. Travis is a former gladiator, a 2-time competitor at Trial by Combat, the premier one-on-one mock trial competition in the country. He's one of just 3 people ever to be selected for the competition as a sophomore. And on the side, he is part of an award-winning a cappella group.
Next, we have Regina Campbell. Regina Campbell is a rising 3L at the UCLA School of Law, where she competes on UCLA's law school trial team. Just a few weeks ago, Regina won the TILA National Trial Competition, making her a law school mock trial national champion. She's also a winner of law school's mock trial's other most prestigious competition, the National Board of Trial Advocacy's Tournament of Champions. No relation. Regina is one of the inaugural recipients of the Sussman Godfrey Prize, which honors the achievements of law school students of color nationwide. And before law school, Regina attended college at the University of Chicago, where she led her team to a 3rd place finish at the National Championship Tournament in 2019. As an undergraduate, Regina won over 20 outstanding attorney awards, including not 1, but 2 All-American awards. She placed in the top 8 in 2 consecutive years at Trial by Combat, and she won the online closing statement championship hosted by the UCLA School of Law in her senior year of college. This summer, Regina will represent the UCLA School of Law at Top Gun, the law school one-on-one mock trial national championship. Oh, Bennett, I think you might be muted.
I'm sorry. That was stupid of me. Sonali. Sonali is a rising 2L at Harvard Law School. I was wondering where Sonali was on screen, where she is a member of the Harvard Law School Mock Trial Association. Before attending law school, Sonali worked for the Office of the Solicitor General of Virginia and coached Duke University mock trial. In 2021, Sonali led Duke's B team to a top 5 finish at nationals in her first season as a coach. Sonali graduated from Duke in 2020, where she was an incredibly accomplished competitor. She won the online opening statement championship hosted by the UCLA School of Law. She and her team won the American Mock Trial Association's One Last Time tournament, a competition for graduating seniors, where she also won attorney awards on both sides of the case. And Sonali is the champion of Trial by Combat 2020, making her the best mock trial competitor of the 2019-2020 season and the owner of the coolest mock trial trophy in existence, an enormous sword.
Finally, it's my pleasure to introduce our presiding judge for our championship trial, Toby Heitens. Our presiding judge, Toby Heitens, is a federal judge on the United States Fourth Circuit Court of Appeals. He was nominated by President Joe Biden in 2021 and has been serving on the court for almost a year. Judge Heitens received his JD from the University of Virginia in 2000, and after graduating, he clerked for former U.S. Supreme Court Justice Ruth Bader Ginsburg. After working in private practice for several years, he became a law professor at his alma mater, the University of Virginia School of Law. In 2018, he was appointed Solicitor General of the Commonwealth of Virginia, where he represented Virginia in their appellate litigation, including cases before the United States Supreme Court. Judge Heitens served as Solicitor General until his appointment to the bench. And now for the stuff that we really care about, Judge Heitens has been the head coach of the University of Virginia's undergraduate mock trial team since the fall of 2006. Under his leadership, they've won the American Mock Trial Association National Championship twice in 2007 and 2017. They finished as the runner-up in 2016 and placed in the top 5 programs nationwide a total of 10 times. In short, the University of Virginia has achieved one of the highest levels of competitive success in the history of college mock trial. Judge Heitens is a member of the American Mock Trial Association Coaches Hall of Fame and is a recipient of the American Mock Trial Association's Neil Smith Award to honor his exemplary commitment to law-related education. Thank you so much for joining us. And with that, it is my pleasure to go ahead and turn it over to Toby to get our final round started.
Well, wonderful. I've been informed that all of the participants from both teams are here. Could I get appearances from both sides, please?
Good evening, Your Honor. My name is Faith Dixon, and I'm an attorney for the state.
Good afternoon.
Good evening, Your Honor. My name is Karthik Ratina Sababati, and I'm an attorney for the state. Our witnesses will now introduce.
All right.
Good evening. My name is Michael DeVoe, but I'll be portraying the role of Nat Lorenzo.
Good evening. My name is Samyukta Venkatraman, but I'll be portraying the role of Emerson Scheikowitz.
Good evening. I'll get appearances from the defense, and then we'll go back to see if what else the state has to discuss before we start. So, defense, please make appearances.
Yes, Your Honor. Good day. Greetings here from China. My name is Jason Junjie Guo, and I'm joined here today by my co-counsel, Zhongru Wu.
Good day, Your Honor.
Good day.
And collectively, we represent Mr. Lawrence in today's round.
All right. Good day.
Good evening, Your Honor.
Good day, Mr. Lawrence. Let's go back to the government. Do you have any matters that we need to take up at this point?
Yes, Your Honor. When it comes to screen sharing exhibits, would you like us to ask your permission or to let the record reflect?
Let's just let the record reflect. I know we're playing a little bit of a game of let's pretend here, but we'll pretend the jury doesn't see things until they should see it. Please just know what you're doing for the record, but you don't need to ask.
Yes, Your Honor. And there are a few stipulations we'd like to read into the record.
All right.
Stipulation 8, both parties agree that Joey Lawrence is the sole owner of Viper Fang Dojo and Danny Lorenzo is the sole owner of Masagi-Do. Stipulation 11 basically entails exhibits 9A and 9B are screenshots of text messages from Joey Lawrence's phone. And stipulation 16, prior to trial, the defendant, Joey Lawrence, was shown all exhibits, including those not referenced in the defendant's interrogation.
All right.
Finally, we'd like the court to take note, invoke Rule 603 that witnesses are constructively sworn, and 615 that all witnesses are sequestered, of course, barring the defendant.
All right.
With that, the prosecution's ready to proceed, barring any statements from the defense.
Defense, do you have anything we need to address?
Yes, Your Honor.
Okay.
Your Honor, if we may direct your attention to case law, State v. Novit, we're going to screen share right here. Your Honor, this case law, State v. Novit here suggests that having intrinsic motivation that results in solicited person's actions is a proper defense to criminal solicitation, Your Honor. We would like it to be on the record.
All right.
With that, defense are ready to proceed into opening statements.
Terrific. Counsel for the government, you may begin whenever you're ready.
This case is about a puppet and a puppeteer. Members of the jury, let's go back to November 12th, 2021. Emerson Shikowitz, a student attending the Viper Fang Dojo, is going to karate practice, practicing for a tournament just the next day. But as the practice ends, the defendant pulls her aside. The defendant hands her nunchucks, and the defendant hands her a slip of paper with an address. Now, with the nunchucks and with this slip of paper, Emerson Shikowitz knew what to do. So Emerson Shikowitz rallied a group of her friends, went to that address, and paralyzed Sam Lorenzo with those nunchucks. Later, she pleads guilty to an aggravated battery charge. Now, members of the jury, today you're going to hear a lot about what Emerson Shikowitz said and heard. However, you're going to hear something else. You're going to hear that behind the scenes was a person pulling the strings to Emerson Shikowitz. That person was the defendant, Joey Lawrence. Emerson was the puppet and Joey Lawrence was the puppeteer. That's why today we have charged the defendant with criminal solicitation. And as the prosecution, we bear what's called the burden of proof. We have to prove that beyond a reasonable doubt that Joey Lawrence intended, asked, or encouraged Emerson Shikowitz to attack Sam Lorenzo. And we're going to do that this trial by showing you 3 points of evidence. Number 1, the defendant gave Emerson a deadly weapon. Today you'll hear that the defendant gave Emerson a pair of his personal nunchucks to paralyze a high schooler. Number 2, the defendant gave her the location. Today you'll hear that Joey Lawrence was the only person at the Viper Fang Dojo who could have reasonably known where Sam Lorenzo could have lived. And he gave that information to Emerson Shikowitz to paralyze a high schooler. And number 3, the defendant told Emerson Shikowitz both explicitly and implicitly to attack Sam Lorenzo. Today you'll hear that at the beginning of the year, Sam Lorenzo was Emerson Shikowitz's bully. But what you're also going to hear is that at the beginning of the year, the defendant told Emerson to beat up Sam Lorenzo if the bullying continued. And you're also going to see a set of text messages from the defendant asking Emerson Shikowitz to do something for him. What is that something, you may ask? To paralyze a high schooler. Now, members of the jury, by the end of today's trial, the evidence will be clear. There was a puppet and a puppeteer. A combination that is likely paralyzed one high schooler and imprisoned another. That's why, at the end of today's trial, my co-counsel, Faith Dixon, is going to ask you to come to the only conclusion supported by the evidence: to find Joey Lawrence guilty. Thank you.
Thank you, counsel. Defense, we'll hear from you whenever you're ready.
Yes, Your Honor. May it please the court. She made up her own mind. Members of the jury, there are a lot of ways for a story to be told. Just now, you heard the opposing counsel portraying Mr. Lawrence as a man who turned his conflict, his prior rage, into action. But what he didn't tell you is, Mr. Lawrence was a middle-aged man. He got no spouse. He got no relatives. The only thing he got is Viper Fang Dojo. He would never encourage anyone in his dojo to do it. In fact, he strongly opposed it. You'll hear from Ms. Shakowitz is violent. She's been angry at Sam Lorenzo for a long time, and she cannot let her anger get away. Sam Lorenzo, on the other hand, have frequent conflicts with Emerson Shakowitz, which makes the latter angrier and angrier and angrier. Members of the jury, Emerson Shakowitz made up her own mind. She found her teammates. She discovered the address and attacked Sam Lorenzo brutally, beating him into a coma. Today, the state has charged Mr. Lawrence with solicitation. They have to prove beyond any reasonable doubts. What it means is that if there's one reasonable doubt, one piece of evidence, or one lack of evidence that makes you think twice, the law compels you to find my client, Mr. Lawrence, not guilty. Members of the jury, at the very end of today's trial, two facts will be clear for all of you. You will learn that Mr. Lawrence did not encourage Emerson. You will learn that Emerson Shakowitz had intrinsic motivation. And that's you'll need. In order to prove these to you, the defense will call two witnesses today. First, we'll call Mr. Lawrence. He is going to testify in front of you that he did not and he would not demand Emerson Shakowitz to attack the Lorenzos before the tournament. You will learn from him that he couldn't be more aware that his dojo would be banned from the tournament if any sort of violence occurred before it. But he needed to attend the tournament this year. He needed to sustain his dojo. You will learn love in karate. You will learn devotion in dojo, and you will learn that he did not do it. You'll also hear from Dr. Peterson, an expert in psychology and also the school counselor from Emerson's high school. She will tell you that Sam and Emerson have personal conflicts, and Emerson cannot let go of her anger. Emerson Shakowitz had intrinsic motivation. Her attack was not influenced by anyone else but herself. She made up her own mind. Members of the jury, our deepest condolence goes to the Lorenzo family. But you need to separate emotions from facts. And that's why, at the end of today's trial, my co-counsel Zheng Ruwu will come in front of you to find Mr. Lawrence not guilty.
Thank you, counsel. Is there anything that we need to take up before the state calls its first witness? Hearing none, the state, please call your first witness.
Yes, Your Honor. The prosecution moves to call Nat Lorenzo to the stand.
All right. You can. Okay, I think everyone's on screen. Counsel, you can begin whenever you're ready.
Good evening.
Good evening.
Could you please introduce yourself to the jury?
Yes, hello, my name is Nathan Lorenzo, but everybody calls me Nat. Sam Lorenzo is my son, and Daniel Lorenzo is my husband.
And Mr. Lorenzo, why are you here in court today?
I'm here to talk about the attack of my son, Sam.
I want to talk about how you know the defendant. How do you know him?
I mean, I've known Joey since high school. Him and Danny have had, let's say, problems since the All Valley tournament of 1985.
You said have had. Could you tell me more about that?
Yes, it's kind of been frustrating. I mean, for the past 30 years, it's been a back and forth. I mean, I don't know that much about karate, but if you ask me, it should have stayed in the past with spandex and leg warmers.
And could you tell me more about this rivalry?
Yes, it's always been a back and forth with them. I mean, recently, Joey opened up the Viper Fang dojo, and then Danny tried to keep them banned from the All Valley tournament. Then Joey gets unbanned, and then Danny creates his own dojo. Honestly, it's getting kind of frustrating.
And why did Danny create that dojo?
Well, it was to compete in the All Valley against Joey and to teach kids karate the right way. His words, not mine.
And how did the All Valley tournament go?
Well, my son, Sam, wasn't actually able to compete.
And why couldn't Sam compete, Mr. Lorenzo?
I remember it all kind of started with a note I had gotten sent to my house. I found it in my mailbox.
Now, when did you receive this note?
It was November 11th.
Let's get that note on the screen. Let the record reflect that my co-counsel is now screen sharing what's been pre-marked as Exhibit 10. Now, Mr. Lorenzo, what are we looking at here?
Oh, I'm sorry. I have to get my glasses. My vision when reading stuff is kind of bad. That's the note. It's practically burned into my brain at this point. That's the note that was threatening my family.
Now, Mr. Lorenzo, what are the initials at the bottom?
It's signed JL.
And is this a fair and accurate copy of that form?
Yes, it is. Yes.
And has this note been altered since you have last seen it?
No, it hasn't.
Your Honor, the prosecution moves to enter Exhibit 10 into evidence.
Any objection?
Yes, Your Honor. Objection as to lack of foundation. May I be heard?
Sure.
We believe opposing counsel is intending to offer this into evidence under Rule 801D2. However, Your Honor, we do have some foundational issues with the declarant being Joey Lawrence.
What issues would those be?
Your Honor, specifically under Rule 901, in order for them to move this into evidence, they have to offer evidence that supports a finding that this purports accurately what they claim this letter is. Now, they can tell us that this is a letter found in his mailbox. They can tell us that this is a letter found on November 10 last year. But quite frankly, anyone could have written this letter. Anyone could have put this letter in his mailbox. We can't say without foundation on the record that this accurately depicts what they claim it to be.
Government counsel, well, first question, are you offering this under 801D2?
Yes, Your Honor. May I be further heard?
Please.
Your Honor, under Spriggs versus McFarland, we have to prove by preponderance of the evidence with the totality of the evidence that we were given. Your Honor, may I make an offer of proof?
Yes.
My witness will further testify to how the note says my dojo, and as read on stipulation 8, Joey Lawrence is sole owner of the Viper Fang dojo. It alludes to the author having students. Joey Lawrence at the Viper Fang dojo has students, and it alludes to the bottom of the letter saying JF, and my witness will testify that the only person he knew with those initials is Joey Lawrence. We have met the preponderance of the evidence standpoint, Your Honor.
So here's what I'm going to do. I'm not going to allow it in right now. I'm going to reserve ruling. Counsel for the state, I think the points you just make are fair. If that evidence comes onto the record, I'll entertain a motion to enter it then. But I think we need to lay that foundation before we enter the document. So for now, I'm not going to let it in, but it's subject to you offering that testimony that you just said and removing it at that point.
Yes, Your Honor. Mr. Lorenzo, who does the author refer to as their dojo in this letter?
I'm sorry, I forgot. I took my glasses off. It says the Vipers are coming.
And does the note allude? And do you know anybody with the initials JL?
Yes, Joey Lawrence.
Your Honor, the prosecution moves to enter Exhibit 10 into evidence.
Yeah, I think the showing is preponderance of the jury could find by a preponderance of the evidence. I think the state has met that, so I will accept the document at this point.
Yes, Your Honor. Mr. Lorenzo, could you read the emboldened portion on this note?
Yes, it says, enough is enough. I'm not going to take this lying down. The way of the fist shows no mercy. You and your students better watch your backs. The Vipers are coming. Signed, JL.
Mr. Lorenzo, after reading this, what did you do?
I'd never been really involved in the whole Joey versus Danny drama, but at this point, this note had crossed the line. It was threatening my family. So I decided to go hear Joey's side of things to see at least why would he send a note like this.
And did hearing Joey's side of things clear anything up?
Well, I never actually heard Joey's side of things.
Why was that, Mr. Lorenzo?
Well, I walked up to the Viper Fang dojo, and before I had actually walked in to talk to Joey, I heard him talking to some of his students, and he was saying things like, today is the day we finish Misagi-Do. Honestly, I was a little confused, considering the tournament wasn't until the next day. And then I saw him hand one person in particular, Emerson, nunchucks and a note.
And Mr. Lorenzo, how are you familiar with Emerson?
Emerson was the person who attacked my son, Sam.
Now, Mr. Lorenzo, after witnessing what you did at the dojo, what did you respond with?
Well, I decided to immediately drive to see Danny, just to explain exactly what was going on. I mean, before this, I hadn't really told him because I didn't really want him to overreact, but I ended up telling him. And then I remember that's when we got a call.
Mr. Lorenzo, who was that call from?
It was from the police. Apparently Sam had been caught up in an attack and he was being moved to the hospital, and he's been in a coma ever since.
I'm sorry to hear that, Mr. Lorenzo. Your Honor, the prosecution has no more questions for Mr. Lorenzo at this time.
Right. I imagine there's a cross-examination from the defense.
Yes, Your Honor.
You can start whenever you're ready.
Sir, I want to start off by talking about the note that you just showed us. Now, you just testified that you found this note in your mailbox.
Yes, I found a note in my mailbox.
The day before the attack?
Yes, I did.
But it wasn't exactly just put there, was it?
Well, no, it had been crumpled. It looked like it had been there for a bit.
That's right, sir. It was not on top of all the other letters.
No, it wasn't.
Now, you'd agree with me that when you saw it, you actually believed it had been smushed by multiple days of mails.
Yes, I would agree with you in saying that.
Now, the day after the attack, it was the day of the All Valley tournament.
Yes.
You'd agree with me that in this letter, Exhibit 10, that it says, the way of the fist show no mercy.
Yes, it does say that.
Sir, it doesn't say the way of nunchucks show no mercy.
No, it doesn't. It's threatening my family.
Your son, in fact, was attacked by a pair of nunchucks. Isn't that right?
Yes, I believe so. I believe so.
Now, I want to move on to talk about what you know about the relationship between your son and Emerson. Now, you just told us in direct examination that you knew Emerson because he attacked your son. Excuse me, because she attacked your son.
Yes, Emerson attacked my son.
What you didn't tell us in direct examination is that you actually knew Emerson well before this attack happened.
Yes, I did. I was familiar with Emerson before the attack.
In fact, sir, you believed that your son was bullying Emerson.
Yes, I remember Sam had made some posts about Emerson, and I told him that bullying wasn't allowed in our home.
Sir, I'm not asking if you told him bullying was allowed or not. You actually believed he was bullying Emerson.
Yes.
Now, let's talk about those posts that you were just talking about. Can we get, Your Honor, we're now screen sharing Exhibit 18 for authentication purposes, constructively outside the view of the jury. Sir, these were the posts you were talking about, right?
Yes, those are the posts.
They were made by your son.
Yes, I'm disappointed in him.
Do they look to be fair and accurate?
Yes.
We offer Exhibit 18.
Any objection?
Yes, Your Honor, as to lack of foundation and to hearsay. May I be heard?
Sure. Let's take those one at a time. Let's start with lack of foundation. What's the problem there?
Well, Your Honor, opposing counsel didn't elaborate on when these posts were made.
Why does that go to foundation?
Your Honor, we'd like the foundation to be laid so we know when Sam made these posts and the time difference between the attack and the post.
So to the extent that's a foundation objection, it's overruled. Anything else?
Hearsay pursuant to Rule 801, they're offering the statements as the comments, the caption, the assertions on the likes, and the assertions on the comments for the truth of the matter asserted.
Counsel for defense, what's your response to the hearsay objection?
Yes, Your Honor. First of all, both parties stipulated before today's trial that Sam Lorenzo qualifies under 804A, an unavailable witness. Furthermore, Your Honor, we believe this goes to 804. We believe this goes to a statement offered against a party that wrongfully caused the declarant's unavailability. Now, the person who made this post, Sam Lorenzo, he was addressing to Emerson, and Emerson was the one who wrongfully caused the declarant's unavailability by beating him into a coma.
Counsel, what rule are you relying? I understand the point about unavailability. What provision of 804 are you relying on?
Yes, Your Honor, specifically 804B6.
You have the ability to screen share a copy of that. I also could find it if you don't.
Your Honor, I hate to interrupt, but 804B6 is not in my rules of evidence.
Court, 1 second. I have a copy of the rule of the rules of evidence. I'll pull that up. Defense counsel, I'm going to give you one last opportunity. I have just checked the rules. In my recollection, it was the same as the state's. I don't see a rule 804B6.
Your Honor, I believe there might appear to be some confusion here. But Your Honor, hearsay is intended to prevent untrustworthy evidence to come in. We do believe that the person who the person who Sam Lorenzo was addressing to was Emerson, and the one who caused him unwrongfully and caused his unavailability. Your Honor, we do believe that that it should be admissible, Your Honor.
Fair, counsel. Although the result may be different in different jurisdiction, the only basis I've heard is Rule 804b6. I don't believe such a rule exists in that jurisdiction. So with that, I'm going to sustain the hearsay objection. That is specifically to the statements, which is what I understand the hearsay objection to be going to. Any other portion of the exhibit is received, but the statements are not.
Your Honor, we objected hearsay to the number of likes, the number of comments, and the captions, since these are assertions made for the truth of the matter.
You got any support for the proposition that the number of likes is a hearsay declaration assertion?
The declarant would be the person liking the photo.
I don't see that has any oral. I'm going to overrule that.
Yes, Your Honor.
Yes, Your Honor. Can we get that exhibit up?
We will treat the statements as constructively outside the vision of the jury.
Actually, Your Honor, at this time, the defense would like to offer this not for its truth. Would like to offer these statements not for the truth of the matter asserted. We like to offer it upon effects on the listener. Your Honor, the effect on the listener specifically in today's case is Emerson.
Response?
Your Honor, if these statements aren't being offered for the truth of the matter, the prosecution has no objection.
All right. Well, with that understanding, they'll be admitted for the limited purpose offered by the defense. Prosecution, feel free to object if you think they're using them in a way that is not permitted under that proffer.
Yes, Your Honor.
Yes, Your Honor. Now, sir, I want to talk about these posts. Can we get exhibit 18A up first? This was the post your son made.
Yes.
If you look at the bottom, it says November 28th, 2021. Sir, that was 2 weeks before the All Valley, before the attack.
Yes, I don't exactly have a calendar with me, but I do trust your math.
Sir, there are 563 people who liked that post.
Yes, it says that.
And your son said, just give up. You could never. And your son used poop emoji, isn't that right?
Yes,
Your son, in fact, was referring to Emerson.
Yes, I can't believe he posted something like this.
Now, can we get to exhibit 18B? Sir, this was another post your son made just a few days after.
Yes, it is.
It was on November 2nd, 2021.
Yes.
Just 9 days before the attack.
I believe so.
At this time, there were 651 people who liked that post.
Yes, there were.
That's a lot of people, sir.
Yes, that is a lot of people.
And your son said, winning feels good, but watching Falcon lose would feel.
Your Honor, they're now bringing these statements in for the truth of the matter asserted pursuant to Rule 801.
In what way, counsel? Sorry, I'm asking counsel for the state, how is this different than what they were doing before?
Your Honor, they read a small portion and the prosecution's on no problem with it, but now they're bringing in the full statement for the truth of the matter asserted and no longer the effect it had on Emerson Shikels.
If I be heard, Your Honor?
Very briefly, yes.
We're happy with a limiting instruction for members of the jury not to consider these statements for its truth.
Yeah, I'm going to overrule the objection. I don't candidly understand how this is any different than the previous theory under which they were using them. So overruled.
Sir, your son said winning feels good, but watching Falcon lose would feel even better, right?
Yes, he did say that. Again, I can't believe he posted something like this. It's unacceptable.
So I'm not asking if whether you believed it to be unacceptable or not. Those were the words he said.
Yes.
And he referred to Emerson as a suck loser.
Yes.
Were there 100 people who made comments?
Yes, quite a few people made comments as well.
Sir, there was in fact 312 people who made comments below that post.
Yes.
Nothing further.
Thank you, counsel. Is there any redirect of this witness?
No, Your Honor.
All right. The witness is excused with the thanks of the court.
Okay.
State, you may call your next witness.
Yes, Your Honor, just one moment to rename myself.
Of course.
At this time, the prosecution calls Emerson Shikowitz to the stand.
Could I quickly rename?
All right. I think the renaming process is done. I see counsel for both sides. So counsel for the state, you may begin whenever you're ready.
Yes, Your Honor. Good evening.
Good evening.
Would you please introduce yourself to the jury?
What's up? My name's Falcon.
Is Falcon your legal name?
No, but do I really have to say it? It's Emerson Shikowitz, but let's just stick to Falcon.
Why the name Falcon?
Well, just hear the name itself, Emerson Shikowitz, it's just such a loser name. But Falcon, that's cool. I've been sticking with it ever since I've been in my dojo, Viper Fang.
And at Viper Fang, do you have a teacher or coach of some sort?
Objection, Your Honor, lack of foundation.
I think it's arguably leading, but I will overrule the lack of foundation objection.
Yes, Your Honor.
Ms. Shikowitz, do you have a teacher or coach of some sort at Viper Fang?
Well, we call him Sensei or Sensei Lawrence, but you might know him as Joey Lawrence. He's kind of the reason why I'm here today.
Why are you here?
Well, I kind of got busted beating up this kid named Sam Lorenzo, but I didn't really want to do it. My sensei gave me the push I needed to.
How so?
There was something about a rivalry going on and money and stuff.
Let's talk about those. You mentioned there was a rivalry. Between who?
Do you watch basketball? I'm gonna just tell you anyway, it's like Duke versus UNC or, LeBron versus Curry. It's a rivalry that's never ending, like the one with Viper Fang and Misagi-Do.
You just told us you're part of Viper Fang. What's Misagi-Do?
Well, it's basically the rival dojo. It's headed by Danny Lorenzo.
Do you know when this supposed rivalry began?
Yeah, according to Sensei, 40-something years ago, him and Danny were at this All-Valley tournament, and they were in the finals. Apparently, they called an illegal kick, and Viper Fang was banned from the comp.
When was the first time you heard about this rivalry?
Well, I can't really tell you an exact time because I joined in February, but like the broken record sensei is, all he says all the time is how Misagi-Do is scum and how he hates Danny Lorenzo.
Well, could you tell us if you remember anything specifically about this rivalry?
You know how I said we were banned for competing? Well, now we're not. Basically, Sensei went to change their minds, just as another way to say beg them to let us compete.
Who's them?
Oh, the All Valley Board people, you know, the competition.
And do you know what the board ended up deciding?
They basically folded and let us compete. It's the closest to a good mood I'd ever seen Sensei, but like all good things, it didn't last long.
You know why?
A couple days later, Sensei was pacing in the dojo, holding a piece of paper, waving a piece of paper, and yelling, "Danny's ruining everything. Fine, if Danny wants war, I'll give Danny war. I'll ruin them."
What happened after Sensei Lawrence said, if Danny wants war, I'll ruin them?
Well, I got a closer look at that flyer, and it said something about Misagi-Do on there, so I just asked, who's Misagi-Do?
Did you get a response?
Yeah, first he was like, Misagi-Do are scum, and we destroy scum. No mercy. Like, it's his first instinct. Then he said, Misagi-Do is headed by Danny Lorenzo, the one that Sensei was beaten by. That kind of got me a little jittery, not gonna lie, because I was like, if they could win again. But Sensei said they won't be competing if he had anything to say about it.
What happened after the defendant said Misagi-Do won't be competing, if he had anything to say about it?
Well, it made its way to the scum. My fault. I'm talking about Sensei. The losers at South Valley High School.
How?
Well, during the first week of school, some kids from Misagi-Do were talking mad smack about our dojo and how we're gonna lose, which got me pretty mad, but I just kept my cool, trying to say that I'll face them on the mat.
You also mentioned earlier that money played a role. Tell us more about that.
Yeah, I think, beginning of November, Sensei was texting me about money.
Would you recognize those texts if they were shown to you in court today?
Yeah, I would.
Let the record reflect my co-counsel is screen sharing Exhibit 9A and 9B for identification. Ms. Shaikowitz, what are we looking at here?
Yeah, these are the text messages between me and Sensei. The ones in blue are mine, and the gray ones are Sensei's.
Have they been changed since you've last seen them?
No, it doesn't look like it.
Your Honor, at this time, the prosecution moves to enter Exhibit 9A and 9B into evidence.
Any objection?
Yes, Your Honor. Objections on the ground of hearsay, specifically to Exhibit 9B, the statements in the blue bubbles, and the statements in the blue bubble, and Exhibit 9A, the last statement in the blue bubble, Your Honor. We believe these are out-of-court statement, offer for the truth of the matter asserted, that was under Rule 801.
Counsel?
Your Honor, looking at Exhibit 9A, okay, be there soon, we're offering this statement for the effect on the listener. While we understand there's no reply from Mr. Lawrence after this, it was the effect that he had to be able to not reply and be able to meet her at the dojo to talk more would be the effect. And as for 9B, Your Honor, we're offering this statement pursuant to Rule 8033, a motive, intent, or plan to be done soon.
Your Honor, if I may be heard? Yes, Your Honor. We'll start with Exhibit 9A here. Okay, be there soon is here being offered for the truth of the matter asserted that Your Honor, that Emerson Shaikowitz had met Joey Lawrence at their dojo on that day. Your Honor, redirecting your attention down back to here, Exhibit 9B. Your Honor, we do not believe this falls into specifically upon plans, because plans need to be very specific here. However, what it says here on Exhibit 9B is merely, got it, we'll get it done. The part here of getting what and getting what done is being very unspecific, and it should not falls into 8033, Your Honor.
Well, I'll take those in reverse order. I don't know where the specific plan requirement is in 8033, so that objection is overruled. On the then existing, so I understand counsel for the government to be saying they're offering the first for the effect on the listener, not for the truth. I guess I understand the objection to just be contesting why they say they're offering it. I'm going to overrule that as well. I think, among other things, the witness could just testify whether she saw him, and so I don't think there's any significant danger of prejudice if it's not being offered for the truth. So both objections are overruled.
Yes, Your Honor.
Ms. Shikowitz, could you read the portions that are highlighted on Exhibit 9A for us?
Yeah. Sensei says, I need you to do something for me. Misagi-Do is ruining everything. We need that 10K. I mean, we're screwed if we don't do something soon.
And can we look at the messages from Exhibit 9B? Oh, sorry. Could you read this message for the jury?
Yeah, this is just telling me to meet him at the dojo to talk more.
Did you?
Yeah, but when I got there, Sensei was just, acting paranoid and walking around in circles. And he was yelling about Misagi-Do again and how Danny's ruining everything. But before I could say a word, he just kicked me out.
Now I want to focus on the messages sent on November 12th of 2021. Would you read these?
Yeah, Sensei says or asks, are you ready to go? Don't forget, strike first, strike fast, no mercy.
What did you reply with?
Well, I said, got it, it'll be done soon.
And did Sensei Lawrence reply to that message?
Not directly, he just went on talking about the gold and how Misagi-Do is going to be skull emojis.
And back to that, are you ready to go message? Did anything happen before these messages were sent?
Yeah, we were at the dojo. I just finished practicing, and Sensei comes out of his office all serious looking. And I was, at that point, he was just shoving a pair of nunchucks and an address in my hand saying, today's the day you win the All Valley tournament. That kind of caught me confused because the tournament wasn't for another day. Then I opened that piece of paper and it had Sam Lorenzo's address on it. After that, he said, don't forget, strike first, strike fast, no mercy. I knew what I had to do at that point.
Well, what did you do after the defendant handed you a pair of nunchucks, Sam Lorenzo's address, and told you today is the day you win the All Valley tournament?
I mean, I did what exactly he said. I went to Sam's house. A bunch of my guys were already at the dojo, so we all just drove. We broke in and we started fighting.
What happened?
As much as I hate to admit it, Sam started winning in the middle. So I pulled out the pair of nunchucks to scare him, but I ended up hitting him in the head with it. After that, it was a bit of a blur. So all I remember was I heard sirens. Yeah, sirens, and I booked it. I got away for about a mile before they put me in cuffs.
And earlier, you said Sensei gave you the push that you needed. Tell us about that.
Look, I'm not the best student or the sharpest tool in the shed, okay? But I'm here right now admitting to my mistakes. I'm owning up to it, but Sensei was the one who gave me those nunchucks and gave me the address that I didn't even know in the first place. He's the one who said we, not him. But we have to do something soon, and we have to end Misagi-Do. I mean, I would do anything for Sensei, and I did. But look where that's ended up for me.
Thank you for your time, Ms. Shikowitz. Your Honor, I have no further questions at this time.
Thank you, counsel. Defense, you may cross-examine whenever you're ready.
Yes, Your Honor. Good day. You beat up Sam Lorenzo, yes?
Yeah, only because I thought I had to do it for Sensei.
Right, let's talk about you and Sam Lorenzo here. He posted Instant posts about you, correct?
Yeah, it was some silly post that he kept on InstaSnap.
After those Insta posts, you talked trash about Sam Lorenzo, right?
I didn't talk trash about him at school, but I just told Sensei.
Is this your sworn testimony today that you didn't talk trash with him at school?
I didn't talk trash with him. I mean, I talked trash about him.
You called him a freak, correct?
Yeah, I mean, he was being cruel, so I just did what he did.
You called him a loser, right?
I called him that a few times, but I know that he called me more.
I'm not asking you whether or not you called him a few times or whether or not he calls you more. I'm asking you that after these instant app posts, you called him a loser. Is that a yes to the question?
Yeah.
You even wanted to punch him badly, right?
Yeah, but I just kept my cool and remembered I'd face him in the math.
Again, I'm not asking you if you get your cool or not. You wanted to punch him badly, right?
I did, but I kept my cool.
You said that you won't let Sam Lorenzo get away with it, correct?
I mean, he was being mean to me, so I was just doing what he did.
I'm not asking what he was doing to you. I'm asking that you said that you won't let Sam Lorenzo get away with those instant nap posts, correct?
Yes, like he did.
Let's talk about why you're here today. You were charged with 2 charges, correct?
Yes, I think, aggravated battery and burglary.
Great. You were made aware by the state attorney that aggravated battery alone will cost you a maximum of 10 years in prison, correct?
I think so. I'm not a lawyer, but I think that's what he told me.
Burglary on its own will cost you another 5 years, correct?
I think so, yeah.
Right, let's do the math here. With both charges, you were expected to get a maximum of 15 years of imprisonment, correct?
Yeah, 10 plus 5.
You're saving yourself by testifying today, right?
I mean, I wouldn't say saving, I'm telling the truth.
Let's talk about this here. By agreeing to testify today, the burglary charge was dismissed, correct?
Well, yeah, but they said it'll only go through if I say the truth.
5 years of imprisonment in here was reduced, correct?
Yeah, only if I say the truth.
Not only that, but agreeing to testify here today, the state agrees to reduce another 8 years on your aggravated battery charge, correct?
Yeah, but my lawyer said it'll only work if I say the truth.
We'll talk about your truthfulness later, but here, let's do the math. You were saved by the district attorney from 13 years of imprisonment. Am I right?
Yeah.
In order to achieve that, you need to provide truthful cooperation to the district attorney, right?
Yeah, they said it'll go through if I say the truth, and I am.
However, that truthfulness is not decided by the judge today. Am I right?
I don't think so. I mean, I don't really remember.
Is this your testimony that your truthfulness today is decided by the judge today?
No, I think so. I'm not saying no.
Mr. Kowitz, this is a very simple yes or no question. Is or is not your truthfulness decided by the judge today?
I think so, yes.
The truthfulness is not decided by the jury today, correct?
I think so.
In fact, your truthfulness is solely decided by the district attorney office, correct?
Yeah.
To clarify, right? Your truthfulness is decided by Miss Faith Dixon, who is sitting right there, correct?
Yes.
You were claiming that Mr. Lawrence pushed you to attack the night before the competition, right?
Yeah, he gave me nunchucks and he gave me an address, and even before that, he told me to go beat him up.
Let's talk about what you claim here. Mr. Lawrence taught you to defend yourself, correct?
Well, yeah, he said better to be on the offense than defense.
However, he never tells you to explicitly attack anyone with the skills you learn, correct?
Not anyone. He told me to attack Sam.
Is this your sworn testimony that he explicitly said that Emerson Shikowitz, go attack Sam Lorenzo? Is this your sworn testimony here today?
No, he said if he makes any other posts, go beat Sam up.
And
when he made the
during
post.
during that conversation, you took it as a joke, correct?
At first, but it got serious when he gave me that nunchuck and the address.
However, you took that phrase when he was saying to beat Sam Lorenzo as a joke and laughed him off, correct?
At the time, but it got more serious once the nunchucks and the address came into play.
So are you saying today that Mr. Lawrence explicitly tells you to attack Sam Lorenzo when he gives you the nunchucks and the address?
No, he told me to go attack him once, and then leading up to it, he gave me a nunchuck and an address.
Right, so it is you who think Mr. Lawrence wants you to do this, correct?
No, he told me before.
So he only told you before? He didn't tell you at that time, correct?
I mean, he kind of gave me nunchucks and an address, so.
Mr. Kowitz, let's be clear here. At that time, it is only you who believes that's what Mr. Lawrence wants, correct?
I'd do anything for Sensei, and I did.
Right. Let's talk about the things he gave you. You said that he gave you a note, correct?
Yeah, Sam's address.
However, prior to your interrogation with the police, that note was nowhere to be found, correct?
I mean, I was fighting, so it probably got lost in the house. The police probably found it.
Mr. Kowitz, I'm not asking you if you're away and fighting. That note was nowhere to be found prior to that interrogation, yes?
Yes, because I lost it while I was fighting.
Well, we have not seen that note today, correct?
Yeah, I mean, I don't know why.
That note never appeared in today's trial, correct?
Not to this point, no.
Nothing further.
Is there any redirect?
Yes, Your Honor.
All right.
Ms. Shaikowitz, what's your understanding of your plea deal?
Well, my lawyer said the agreement only goes through if I say the truth, and I am saying the truth.
And opposing counsel also mentioned Sensei giving you the push. How did you do that?
Well, he gave me a push by first telling me to go beat up Sam when he made that post. Then, up to that, he was telling me how much he hated Misagi-Do, and at a point he said, we have to end Misagi-Do. Then on the day, he gave me nunchucks and an address, so I did what I had to do for my sensei.
Nothing further.
Right. Is there any recross based on that?
No, Your Honor.
Okay. The witness is excused with the thanks of the court. I believe that the state has no further witnesses, but is there anything else we need to take up before we take a brief break?
No, Your Honor. Prosecution's good to break.
Terrific. Let's take 5 minutes. I know we're all in different places, but let's come back at 33 in whatever time zone that you're in right now. I'll see you then.
Yes, Your Honor.
Yes, Your Honor.
All right. Are the parties back?
Yes, Your Honor. Defense, we're back, we're present, and we're ready to proceed.
Yes, Your Honor, the prosecution is ready to proceed.
All right. Let me just make sure the scoring judges are all back. Could you all just message me and let me know that you're here? I don't want to obviously have them miss any of the trial. I'm getting notices. I'll let you know when I've got them all.
Yes, Your Honor.
Yes, Your Honor.
I have them all. So the scoring judges are all present as well. Unless there's anything we need to take up before then, defense, you can call your first witness.
Excuse
Yes,
me,
Your
Your Honor. I'm sorry that I'm here experiencing some school policy issues. May I solve it in 2 minutes so that we can proceed?
Sure.
Sorry for the inconvenience, and thank you for your understanding.
Your Honor, we do want to have the court's condolence on this.
Sure thing. Just let us know when you're ready to go.
Yes, Your Honor.
Your Honor, I'm back here, and I think the defense is ready right now.
All right. All right.
Your Honor.
Well, with that resolved, defense, you can start whenever you're ready.
Yes, Your Honor. Good day. Would you please introduce yourself to the members of the jury?
Joey Lawrence, at your service.
Sir, what do you do for a living?
Well, I'm the owner and the sensei, meaning teacher, of the Dojo Viper Fan. I once studied philosophy in Emory, but I got tired of it and all the other jobs I've done in my life, so I decided to step back to what I'm good at.
Sir, what are you good at?
Well, karate, of course. When I was a kid, I learned and I practiced, then I go to tournaments. I can still remember my first time holding that championship medal in my hand. It was so unforgettable.
Sir, could you tell us a bit about Viper Fan?
Oh, sure. Viper Fan, my dojo, the best one in town. And there, I train students to become great karate fighters. And I also teach them when and where to use their skills. Events on the ring, stays on the ring. I teach them to respect this.
Sir, let's take a step back here. What made you want to start this dojo in the first place?
Well, as a matter of fact, I restarted Dojo Viper Fan, where I got trained for karate when I was very young. I personally love the skill and I want to spread it. The Valley also has a tournament for it, the All Valley Tournament.
Sir, could you explain to the members of the jury what is the All Valley Tournament?
Oh, All Valley, the tournament. Every year, hundreds of dojo come and compete for that only championship, which we were supposed to win this year.
Sir, what do you mean when you say you were supposed to win?
I mean, the Vipers, we're really practicing hard for that tournament because this is our first year returning from our ban, which lasts for almost 40 years. So we really want to win this. Unfortunately, we got banned again.
Sir, why did Viper Fan get banned again?
It was because of my students, Emerson Shekels and others. They attacked members of the Masagi-do on the night before the tournament. That action was taken as an unsportsmanlike conduct, just like what happened almost 40 years ago.
Sir, did you encourage this attack to happen to have your dojo banned?
No, I already learned from the past that this kind of events causes you great trouble. Events on the ring has to stay on the ring.
Sir, let's talk about what you learned from the past. All right? Why was your dojo banned 40 years ago?
It was because of my sensei and my colleagues in old Viper Fang. They beated members of another dojo before one All Valley tournament because they were taunted. After the tournament, we were figured out, and that action was considered as an unsportsman conduct. So we got banned. Although it's not me who did this, I still learned my lesson.
Sir, what lesson did you learn?
Since then, I understand that any violent action before a tournament causes you big trouble. Because my dojo means much to me, I made a promise to myself that I'll never let this kind of thing happen to my new Viper Fang again.
What exactly does your dojo mean to you?
Viper Fang means everything for me. It's the place where I learn my beloved skill. It's the place where it holds my past, my present, and my future.
Sir, would you harm Viper Fan in any way?
Of course I won't. I made a promise to myself about that.
You said you learned a lesson from the past. Let's talk about what happened last year. To the best of your knowledge, what could happen to your dojo if you violate the rules again?
Well, we definitely get spammed. Then I break the promise I made to myself, and we probably will never return again.
Mr. Lawrence, after Emerson attacked the victim, was Viper Fan banned from the Old Valley tournament?
Yes, we were. 5 days after that incident, we got disqualified. My worst nightmare happened on me again.
Sir, was Viper Fan harmed?
Harmed. Viper Fang was destroyed. I can't pay my rent. I'm in debt. My students, they leave me. The committee stopped trusting me. I lose everything. Everything.
Sir, do you have anything to do with the violence incident that had occurred?
No, I don't. How would I do such thing that I know will destroy me and the place where it holds everything for me? If I know what could have happened, I will definitely prevent Emerson from doing this.
Nothing further, Your Honor.
All right. State, you may cross-examine whenever you're ready.
Yes, Your Honor. Mr. Lawrence, before I continue with this cross-examination, I just want to make sure you can see and hear me perfectly.
Yes, I can.
Now, I'd like to talk about your history with the Lorenzos. You've known Danny Lorenzo for quite some time, right?
Yes.
Routing back to the 1985 All Valley tournament.
Yes.
And at that tournament, he had you disqualified for an unsportsmanlike conduct charge, right?
Yes. Danny was the one who reported this charge to the committee.
And he had your team permanently banned from the All Valley tournament, right?
Yes, but it was part of our responsibility.
That ban got broken here in 2021, right?
Yes, I tried my best to get us unbanned.
And when you did have that ban got broken, Danny Lorenzo tried to uphold it, right?
Well, yes.
I'd like to talk a little bit about the history behind your dojo. When you restarted your dojo, you kept the same name as you did in the 80s, right?
Yes, I did.
And along with the same name, you kept the same motto, right?
Oh, yes, I did.
That motto was to strike first and to strike fast, right?
Yes.
And you taught your students to live by that motto, right?
Yeah, but more precisely, I'm aiming to let them know if they're not the first in something, they're the last. What I learned from my parents when I was really, really young.
Exactly. You live by that motto, right?
Of course.
Now, let's talk about a time that you did live by that motto. 2 years ago, you were convicted of aggravated battery, right?
Yes, I was.
And this was when you attacked a group of teenagers in a parking lot.
Objection, Your Honor. Based on Rule 403, substantially more prejudicial than probative and likely to cause misleading and likely to mislead the juries, Your Honor.
Okay. Response?
Your Honor, actually on direct examination, Joey Lawrence testified to how he would never let this kind of thing happen. Violence before a competition. Your Honor, they opened the door on direct examination for this conviction to be brought up during cross-examination.
Your Honor, may I be heard?
You may.
Your Honor, the general aggravated battery charge that was being charged on Mr. Lawrence 2 years ago have no probative value at all in today's case. However, will only brings prejudicial value towards to mislead the juries to believe that Mr. Lawrence was a criminal, Your Honor. And in fact, Your Honor, sorry, I thought there was some noise that happening over there. And in fact, Your Honor, Mr. Lawrence started his new dojo after the felony was charged, Your Honor. So, as a result, I still stands by my argument around Rule 403 on substantially more prejudicial than probative.
I'm going to overrule the objection. I don't think the defense is allowed to have it both ways of claiming that their client is a saint and then objecting to evidence that suggests maybe their client isn't a saint. So objection overruled.
Now,
Yes,
Mr. Lawrence, my apologies. Mr. Lawrence, this is when you attacked a group of teenagers in a parking lot, right?
Oh, yes.
While exclaiming, "The way of the fist shows no mercy."
Yes, when I get really angry, I do say so.
Now, it's true that the Viper Fang Dojo has been quite taxing on your expenses, right?
Excuse me, I didn't get your question clearly. I'm sorry about that.
You're fine, Mr. Lawrence. It's true that the dojo has taken quite a lot of money from you, right?
Oh, yes.
I'd like to get your bank statements from the year of 2021 up. Let the record reflect that my co-counsel is currently screen sharing what's been pre-marked as Exhibit 7A and 7B. Now, Mr. Lawrence, these are your bank statements from the year of 2021, right?
Yes, they are.
These statements were made on December 15th, 2021, right?
Yes, they are.
And they were made by the banker Reseda.
Yes,
And they were regularly updated, right?
of course.
In fact, you got one of these statement sheets every year, right?
Yes,
And this is a fair and accurate representation of your bank statements from the year of 2021.
yes, it is.
These have not been altered since you have last seen them.
No,
Your Honor, the prosecution moves to enter Exhibit 7B into evidence.
Any objection?
Your Honor, no objection to specifically Exhibit 7B, but we do ask Exhibit 7A not to be entered, Your Honor.
Any problem with that from the state?
No problem with that from the prosecution, Your Honor.
All right. Exhibit 7B is received.
Thank you, Your Honor. Well, now, Mr. Lawrence, I'd like to talk about your finances. The rent for Viper Fang every month was $3,900, right?
right.
And when you first started your dojo, you were making plenty of money to cover that charge, right?
Oh, yes.
But that changed in June, right?
Oh, yes.
That was when Danny had opened Misagido, correct?
Around that time, yes.
It is your prior testimony that you had never felt more angry in your life than when you saw that flyer of Misagido.
Well, it triggered me, yes.
Every month after that, your tuition just continued to drop. Right.
Sadly, yes.
By November 12th, you didn't have any funds left in your bank account to pay your bank statements. Isn't it true?
It is true. So I needed that 10K.
Oh, no. Mr. Lawrence, this was the day before the tournament, right?
Yes.
And the same day that Emerson attacked Sam Lorenzo, right?
Well, yes.
No further questions at this time, Your Honor.
Okay. Is there any redirect?
Yes, Your Honor.
All right.
Shall I proceed?
Yep.
Mr. Lawrence, the opposing counsel was just asking you about your financial status. I'd like to ask you to explain how exactly your financial status is to the members of the jury.
Well, you see, I am earning little money and I do need to pay my rent. That's why I need the tournament. If we win that 10K, I can save my Viper Found. If we attend the tournament, I think really have pretty much a chance to win it. But now
Your Honor, we do believe there is a bit tech issue at my witness part.
That appears to be the case from my end too.
Prosecution has no problem pausing time until your witness is connected.
Yes, of course. One sec, Your Honor. We're having some internet issues right here.
Understood.
If we may have the court's condolence.
Of course.
my apology, Your Honor. We just experienced some tech issue right here, and
Understood.
we use my text computer.
All right. Counsel, you can continue whenever you're ready.
Yes, Your Honor. Just picking up from what you left, why do you need that 10K?
It's because otherwise there's no way for me to save my dojo. I have to pay my rents, and that's the only chance for me to win money.
Could you get the 10K if your dojo get banned from the All Valley tournament?
How can I get the money if I couldn't attend that competition? We really had a good chance of winning it. But after we get banned, I can just watch Viper Fan die, doing nothing.
Nothing further.
Is there any recross?
No, Your Honor, no recross from the state.
All right, the witness is excused. Defense, please call your next witness.
Yes, Your Honor. The defense calls Kai Peterson to the stand.
Okay.
Please introduce yourself to the members of the jury.
My name is Kai Peterson.
What do you do for a living?
I'm a licensed clinical social worker at Morville. Currently, I work at South Valley High School, and I've been working with adolescents with anger-related disorders for over 14 years. I really enjoyed working with these kids because it gives me a chance to help these kids out so that they can become better functioning members of the society.
Doctor, how do you help these kids to become better functioning members of society?
That includes psychological evaluations and provision of mental health and anger management training.
Before we get to your conclusions, can you tell us a bit about your educational background in adolescent psychology?
Of course. I received my master's degree in social work from The Ohio State University with a certification in adolescent social work in 2008. Then, in 2013, I completed my PhD in adolescent psychology at Morville State University. Majority of my research is focused on diagnosing and treating anger-related disorders in adolescents.
Dr. Peterson, have you ever testified in a court before?
Yes, I've already served dozens of times in court and have testified 8 times as an expert witness regarding the evaluation of adolescent behaviors.
And why are you here in court today?
I'm here today to offer my expert opinion on factors causing Emerson Shikowitz's violent behaviors.
Specifically, what facts and data, doctor, did you rely upon to come to analyze Emerson Shikowitz's behaviors?
I relied on the information I collected during our bi-weekly counseling sessions about anger management training, which I had with Emerson. Furthermore, I also relied on the test result of the personal anger assessment test that I gave to Emerson. I also reviewed the social media posts that Emerson showed me during our previous counseling sessions.
What methods did you use to come to your conclusions?
The standard practice in our field is to use a trigger-oriented method. A trigger is a reminder of past trauma, and they help us to identify why a patient might be acting out in the first place. Our method is to find the trigger, observe the trigger, and finally, analyze the trigger. We do this through regular counseling sessions, and that's how I reached a conclusion in today's case.
Is that a reliable method?
Yes, it is a gold standard in my field, and it is commonly applied.
And doctor, did you reliably apply it in today's case?
Yes, I did. I strictly follow the standard.
Now, what is your conclusion regarding Emerson Shikowitz's violent behaviors?
Based on my conversations with Emerson and our counseling sessions, I conclude that her experience of being bullied is the major trigger of causing her unexpected violent behaviors, including uncontrolled shouting, verbally threatening other students, and physically fighting Sam Lorenzo. I observed her progression of anger from around April all the way to November when the incident happened.
Doctor, let's break that down a little bit. You said progression of anger. When was the first time you talked to Emerson?
It was on April the 22nd, 2021.
And what did you learn from your conversation?
Well, I learned that before Emerson herself has become a bully, she has been extensively bullied by other people for years. And this experience of being bullied acts as a common trigger. And it's actually quite common for many cases that I've seen in the past 14 years. Many adolescents that have been previously abused by other people tend to internalize their anger and become bullies themselves. Unsurprisingly, Emerson said that she wasn't even regretting about bullying people around her and believed that people around deserved to be bullied.
And specifically, how did Emerson behave during your conversations?
Emerson shouted a lot during our conversation, and she seemed visibly irritated and angry. It shows me that she could be potentially struggling with anger management issues, so I gave her a personal anger assessment test.
Can you explain to us what is a personal anger assessment test?
Of course. A personal anger assessment test contains some questions that can help us to better identify any anger management issues that the patient might be experiencing.
Would you be able to recognize the test Emerson took if I were to show it to you?
Yes.
Screen sharing exhibit 19. Doctor, this is the test Emerson took.
Exactly, it's the same one. Yes.
Does it look to be fair and accurate?
Yes, it does.
We offer exhibit 19 into evidence.
Any objection?
Yes, Your Honor, on two grounds. First, hearsay under Rule 801 and improper character evidence under Rule 404.
Okay, let's start with the hearsay for a moment. This is a hearsay statement by whom?
Well, Your Honor, actually, hearsay within hearsay under Rule 805. First, the statements themselves on the document without Emerson's responses, and then Emerson circling the responses is another layer of hearsay.
Okay, counsel, respond to that, please.
Yes, Your Honor, this is admissible under 703. Dr. Peterson just testified that these were the facts and data she relied upon in order to come to her conclusions.
Counsel, what's your response to that?
Your Honor, I'm not sure if much foundation has been laid on the record that Dr. Peterson used exactly this response and formulated a treatment plan for Emerson Shikowitz.
Well, that's not really a hearsay objection, though, is it?
Me, Your Honor?
Yes.
Oh, yes, Your Honor, the response to the 703, that I'm not sure that enough foundation has been laid to say that Dr. Peterson relied on this document to come to her conclusions regarding Emerson Shikowitz and her treatment plans for her.
Okay, counsel, response to that, please.
Yes, Your Honor, this doctor, in fact, did testify that she relied upon this fact to come to her conclusions.
Yeah, that's my recollection of what she said. Could you respond to the, sorry, counsel for the government, that's a character evidence objection you said?
Yes, Your Honor.
Counsel for the defense, could you respond to that, please?
Yes, Your Honor, we believe this falls under character evidence exception 404B. Your Honor, we believe that this goes to show that Emerson Shikowitz has an intent to commit this aggravated battery by her intrinsic motivation. It's the defense contention in today's case that it was her intrinsic motivation that caused this aggravated battery to happen.
Okay, counsel for the government, what's your response to that?
Your Honor, it doesn't go to Emerson Shikowitz's intent to commit an aggravated battery. You see, this anger assessment test was taken back in April. That's 7 months before the aggravated battery. So it couldn't go to her intent to commit it.
That strikes me as going to weight, not admissibility. Objection overruled.
Yes, Your Honor. Doctor, what was the result of Emerson's anger assessment test?
If you look at it, Emerson's responses indicated that she may struggle with impulse control and may be more likely to act on conflicts with other individuals around her.
To make things clear, what do these numbers represent?
These numbers are scaled from 1 to 5, all the way from 1 meaning never to 5 meaning always.
Did any answers stick out to you in this test?
Yes, there are 3 questions that particularly stand out to me. They are question 3, 16, and 18. I'd like to go over the questions that Emerson circled 5.
What are the questions that Emerson circled 5 always?
Emerson indicated that it's always hard for her to let go of thoughts that make her angry. She always gets so angry, she feels like she's going to explode with rage. And she always remembers people and situations that make her angry for a long time.
Doctor, what does this show to you?
These answers I just mentioned all prove that Emerson is having trouble with handling her own anger.
Now, I want to talk about what happened afterwards. What did this test lead you to do?
The results of the test has shown that overall, Emerson could improve on how she handled her anger. However, a single test was never enough. So I believe some followed-up appointments were definitely necessary in order to fully diagnose and assess Emerson Shikowa's behavior.
And did Emerson, in fact, get better in your follow-up appointments?
Well, apparently not. During our biweekly sessions of September the 28th, 2021, Emerson seemed to be even more prone to aggression. This time, she has escalated into some physical conflicts with other people around, but interestingly, her aggression were specifically towards one individual.
I want to be clear, Doctor. Who is that one individual?
It's someone named Sam Lorenzo.
What did Emerson tell you about Sam Lorenzo?
Well, I recalled Emerson telling me that Lorenzo is a karate student at her opposing dojo, and Lorenzo has teased Emerson in person and on social media as well.
Now, screen sharing. Screen sharing exhibit 18. Doctor, are these the posts you were talking about?
Yes, they are.
Now, what stuck out to you in this screenshot?
Well, I would like to direct your attention to the specific word choice of these two posts. Emoji and word choice such as never, sucks, and losers are pretty provocative and might trouble Emerson, who is currently undergoing anger management issues.
Objection, Your Honor. Improper expert opinion. May I be heard on this?
Please.
Well, Dr. Peterson is testifying specifically to these statements and what effect they would have on Emerson Sheiklitz. She's not allowed to testify to Emerson's state of mind or what these messages would mean to her.
Your Honor, yes, Your Honor, she has a doctorate in adolescent psychology. It's well within her expertise to testify to what science says. And Your Honor, in fact, here, he just testified to that these statements are provocative. That's well within her expertise to testify under 702.
Last word to the state.
Yes, Your Honor. Just as opposing counsel said, Dr. Peterson has a doctorate in adolescent psychology, not interpreting messages and what effect they would have on someone's mindset. That's stepping outside of the expert category and stepping into what Emerson Sheiklitz is thinking.
I think it's a close call, but I'm going to overrule the objection. I think this is sufficiently within what she does. So objection overruled.
Yes, Your Honor.
Dr. Peterson, what was Emerson's behavior like when she discussed Sam Lorenzo?
Emerson refused to sit and continued pacing around the entire room. She seemed so frustrated and irritated. It was the angriest Emerson I had ever seen.
Now, did Emerson say anything specifically?
Yes. Emerson said she wanted to punch Sam Lorenzo.
When was the next time you heard about Emerson?
Well, it was 2 weeks after Emerson last complained about Sam Lorenzo. I learned that Emerson used violence to deal with Lorenzo, and given the context of our previous conversations and the angry temper of Emerson, I wasn't so surprised that the fight finally occurred.
Now, have you heard about someone named Joey Lawrence?
Yes. Emerson and I once had a short conversation about Joey Lawrence.
What did you learn about him?
I learned that Joey Lawrence is Emerson Shikowa's karate teacher, and they've been spending a long time together.
Dr. Peterson, you testified that Emerson's violent behaviors were triggered intrinsically. And isn't it possible that Joey Lawrence could have affected her?
Well, it is possible, but very unlikely. Emerson told me that she has never been pressured by her karate teacher to act violently at school. In fact, even when Emerson shows her anger, she never brought up her karate teacher, not even for once. So the influence from the teacher plays a rather insignificant role.
Finally, doctor, what is your final conclusion about Emerson's violent behaviors?
Based on my conversations with Emerson, I concluded that her anger and violence towards Sam Lorenzo is triggered by her being bullied, agitated by her unpleasant interaction, and escalated by her own bad temper. It is my professional opinion that Emerson made up her own mind. The major causes of
Objection,
Emerson's
Your Honor,
violent
speculation.
actions.
Sorry, counsel, the objection?
Speculation as to Emerson made up her own mind.
Yeah, counsel, I'm going to give you a shot, defense counsel, but I'm a bit skeptical of the witness's ability to say that.
Yes, Your Honor, we can ask this witness to rephrase.
Well, then we're going to strike the statement that she made up her own mind, and you can ask another question. Thank you.
Dr. Peterson, what are the major causes of Emerson's violent behaviors?
Sure. The major causes of Emerson Shikowitz's violent behaviors come from her experience of being bullied and agitated by her unpleasant interaction and escalated by her own bad temper. It is my professional opinion that the major causes of Emerson Shikowitz's violent actions come from herself.
Nothing further.
Right. I suspect there's a cross-examination. I'll let you get in position, counsel, and you can start whenever you're ready.
Yes, Your Honor. Dr. Peterson, can you see and hear me okay?
Yes, I can.
You just testified on direct examination that Emerson committed, she had her own actions. She committed her own actions.
Yes.
Well, it's true that children are particularly susceptible to influence from adults.
Generally, yes.
And you've seen this in your line of work before, haven't you?
Yes, I did.
Your line of work being on-call clinical social worker at South Valley High.
Yes.
I want to talk about that work at South Valley High. Well, you came there, the bullying, it started to escalate, didn't it?
Sorry, counsel, could you repeat your question? I'm having a little bit internet issue.
Of course. When you came to South Valley High, the bullying, it started to escalate, didn't it?
Yes, it does.
And you noticed a lot of students were coming to you about Emerson Shekowitz, true?
That's true.
And after hearing all of these students come to you about Emerson, you started bi-weekly sessions with her, right?
Correct.
And you noticed that she had told you she had been bullied for years at South Valley High.
Correct.
But you'd never come in contact with her before February of 2021.
No, I did not.
And you are aware that Ms. Shekowitz joined the Viper Fang Dojo in February of 2021?
Correct.
You also had Ms. Shekowitz take an anger assessment test before you started seeing her, didn't you?
Yes, it was on our first session. Yes.
Your first session in April of 2021?
Correct.
And you said on direct examination that a single test was never enough, right?
Correct. That's what I said.
You never had her take another test after April?
No, I didn't give her another test.
Even after you saw her aggressive tendencies getting worse?
Correct, counsel, but I like to clarify, I didn't give her a test, but I also have counseling sessions and conversations with her to base my conclusion, but yes.
Now, I want to talk about what you learned in August of 2021. It was then you'd come to realize that she could have been pressured by her sensei to act aggressively. Isn't that true?
At that exact moment, I initially believed so, yes.
And at this point, Emerson had never gotten into a physical fight before at school.
At that moment, no.
And in October, she had never gotten into a physical fight before. Isn't that true?
To my knowledge, that's true. Yes.
And before November 12th of 2021, she had never gotten into a physical fight. Isn't that true?
Again, to my knowledge, yes.
And before November 12th of 2021, Ms. Shikowitz, she came into your office pretty upset.
She did.
She was saying she wanted to punch Sam Lorenzo so badly.
Correct.
But she promised you she wouldn't do anything unless something had changed.
Correct. That's what she told me. Yes.
She also told you her sensei had never encouraged her to be violent at school.
Correct.
10 days after you had your last bi-weekly session with Ms. Shikowitz, you were told there was an altercation between her and Sam Lorenzo.
Correct.
You don't know where this altercation took place?
No, I did not.
And you cannot rule out that Ms. Shikowitz could have been influenced by someone else to act aggressively. Isn't that true?
Correct. I cannot 100% rule out that there are other triggers.
And it's also true that you were shocked Miss Emerson went back on her word.
Yes, at that moment I was.
Nothing further.
Right? Is there any redirect?
No redirect, Your Honor.
All right. Well, the witness is excused with the thanks of the court then. Are there any go ahead.
Your Honor, I just said the defense rest.
Excellent. Is there anything else we need to take up before we take a brief break before closing arguments?
Nothing from the prosecution, Your Honor.
Nothing
All
from
right.
the defense. No.
Well, let's take 5 and we will come back on the 21. I'll see you then.
Yes, Your Honor.
All right, are the parties back?
Yes, Your Honor, prosecution's here and ready to proceed.
The defense is ready as well.
Great, and I'll just give my fellow judges a minute to confirm they're back, and then we'll get ready. Just waiting on a couple. All right, the judges have confirmed they are back, so we will move into closing arguments, starting with the prosecution. You can begin whenever you're ready.
Before I begin, Your Honor, if I may reserve any remaining time for a rebuttal.
Of course.
Members of the jury, I just want to start by reminding you of why you're here today. It's because Sam Lorenzo was left with swelling in the brain, fractures, internal bleeding, abrasions, and bruises. And Ms. Shikowitz, she's already pled guilty to her crime against Mr. Lorenzo. She'll be in jail for at least 2 years. But she didn't commit this battery because she wanted to. She had to. And that's why we're here today. We're charging the defendant with criminal solicitation. Before we talk about the evidence, I want to talk about the law. We didn't have to show that Joey Lawrence specifically said, go fight Sam Lorenzo. All we had to prove to you today was beyond a reasonable doubt was that Joey Lawrence was guilty of criminal solicitation. Basically, that means we had to show you that Joey Lawrence intended for Ms. Shikowitz to commit a crime against Sam Lorenzo. And the law says that what the defendant did, finding a puppet to commit that revenge is enough to find him guilty. And I'm going to take you back to the beginning of this trial, when my co-counsel Karthik Rathnasabapathy asked you to keep 3 points in mind. 1, the defendant gave Emerson a deadly weapon, nunchucks. 2, the defendant gave Emerson verbal encouragement. And 3, the defendant gave Emerson the address of Sam Lorenzo's house. Number 1, the defendant gave Emerson a deadly weapon. Now, nunchucks, they're perfectly legal if they're used inside of a dojo or inside of a competition arena. But the moment they're taken outside of where they're supposed to be used for, they become illegal. The moment Ms. Shikowitz used those nunchucks on Sam Lorenzo, they became illegal. But we brought you more evidence than that. Number 2, the defendant gave Emerson Shikowitz Sam Lorenzo's address. Not only by just handing her Sam Lorenzo's address, but by telling her, today is the day you win the All Valley tournament. That was the next day. Members of the jury, there's only one person who knew where the Lorenzos lived, Joey Lawrence. There's only one person who left a threatening note to Nat Lorenzo, Joey Lawrence. There's only one person who used Emerson Shikowitz as a puppet for revenge, Joey Lawrence. How else would Emerson have gotten to Sam Lorenzo's house without the defendant's assistance? Number 3, the words that Mr. Lawrence said make his intent crystal clear. Not only did he give Emerson verbal encouragement, today's the way you win the All Valley tournament, he set his words in stone with text messages that you saw today. Just a week before the crime, he says, I need you to do something for me. I mean, we're screwed if we don't do something soon. Soon being November 12th, 2021, when the defendant said Masagi-Do is dead. And Emerson replies with, got it, it'll be done soon. Well, if the defendant truly in his heart of hearts didn't know what was going to happen, he would have said, done with what? Emerson, what are you talking about? I think you misunderstand. I'm talking about the tournament here. You must misunderstand my words. But he didn't, because he knew exactly what was going to happen. It was all according to the defendant's plan to have Miss Scheikele beat up Sam Lorenzo. As the prosecution, we had to prove to you that Joey Lawrence is guilty of criminal solicitation. And we've done so. We've done so by showing you the defendant gave Emerson the address, verbal encouragement, and a deadly weapon. And I'm sure Mr. Wu will get up here and tell you that Emerson, she made up her mind. But you learned that Emerson was just a puppet in the defendant's puppet show. And we're asking that you find him guilty. Thank you.
Thank you, counsel. We'll hear from the defense now.
May I proceed?
You may.
May it please the court. She made up her own mind. Members of the jury, you've met Joey Lawrence today. He's a sensei. He's a middle-aged man. His dojo is broke. His broke. And frankly, members of the jury, he ran his dojo out of pure idealism because karate is what he loves. Does not have a family. Members of the jury, after all these happened, he lost his dojo. His dojo was banned again. That 10,000 K he wanted to use to sustain his dojo was gone. His dream was broke. Members of the jury, the prosecutor just came up here and they wanted you to believe that there was a tragedy happening. That's not disputed in today's case. But members of the jury, they wanted you to believe that the defendant was behind all these. They wanted you to believe that Emerson broke into Sam's house, caused him bleeding, caused him bruises, and they wanted to believe that it was the defendant who persuaded her to do so. The law requires that they have to prove it to you beyond a reasonable doubt. But members of the jury, there were mountains of doubts in today's case. All you got to do is to keep track of the two facts my co-counsel asked you to at the beginning of this trial. First, Emerson Scheikele had intrinsic motivation that he hated Sam so that he beat Sam up. Second, Joey Lawrence had no reason to want for this crime to happen. First, you've heard the prosecutor just came up here and told you that it was a puppet controlled by a puppeteer. But frankly, members of the jury, if there's only one puppeteer in today's case, that would be Emerson's own anger. That would be Emerson's own intrinsic motivation, because you heard Dr. Peterson testify today. You've heard Dr. Peterson with her 14 years of experience in adolescent psychology. She was able to conclude to you that Emerson's violent behaviors, which was triggered by her hatred toward Sam Lorenzo, because you see, Sam Lorenzo was bullying her. Members of the jury, you've seen those internet posts. You've seen how Sam Lorenzo called her a suck loser. You've also heard Dr. Peterson told you that when Emerson talked about Sam Lorenzo, she said, I wanted to punch him. Which brings us to the second point. When Emerson Shikowitz had every reason to commit this crime, the defendant didn't have a single of them because, in fact, the defendant would have prevented it if he were to know. Because you see, the defendant learned a lesson from 30 years ago. The defendant learned that his dojo being banned does not feel good. That his dojo being banned takes something away from him. That's why he learned a lesson that he never wanted for this to happen again. That's why the only thing that could sustain his life, his love for karate, would never allow him to believe that something like this was going to happen. You've heard Emerson Shikowitz testify on stand today. When my co-counsel asked her, "Ma'am, this is going to save you 13 years of imprisonment by testifying here today, right?" She said, "Yeah, sure." And that's the exact reason why we can't trust her, members of the jury. When the prosecutor brought their case today, when they relied their entire case on a lost note that they claimed to have Sam's address on it, when they rely their entire case on a pair of nunchucks that was supposed to be used for a martial arts competition, when the state relied their entire case on a few text messages and emojis, when the state relied their entire case on a single witness we can't trust, members of the jury, that is blame. And that's why I'm going to ask you to find the defendant not guilty. Thank you.
Thank you, counsel. And we'll hear from the state with their further rebuttal.
Mr. Wu just told you that the defendant didn't have a single reason to have Emerson Shikowitz commit that aggravated battery. He had 10,000 reasons to have Emerson do exactly what he wanted to do, to have Miyagi-Do not compete in that competition, to knock out their greatest competition so the defendant could get $10,000. And Mr. Wu wanted to talk about who he couldn't trust. Emerson Shikowitz? No, let's talk about the defendant. The defendant who beat up 5 children in a parking lot. The defendant who gave Emerson Shikowitz a deadly weapon. The defendant who said, "We need to finish Miyagi-Do once and for all." The defendant who used Emerson Shikowitz as a puppet. Find him guilty for criminal solicitation. Thank you.
Thank you, counsel. The judges are going to take a moment to submit our ballots, and then the folks will be getting to the results. I'll ask my other fellow judges as they finish up and submit the ballot, if they could turn their video on so you can hear from them while we wait to get the results. But in the meantime, while I wait for that, congratulations. Great job, everyone, and looking forward to seeing the results soon. So again, fellow judges, when you get done, if you could just turn on your video, and then we'll do some brief feedback. Hello, Regina. You want to start us off?
Oh, should I wait until everybody else is done submitting, or because I don't want to influence people, or do you think it matters?
I think I trust these folks to not be unduly influenced by anything that you or I were to say. So I think you can start off.
Sure. So great job, both teams. I was super impressed. I cannot believe you guys are in high school. I could not do this when I was in high school. So I'm really proud of you guys. Great work, great job. Great witnesses, great attorneys. Obviously, you guys have probably been hearing great all weekend, and you're going to get more of it from me and the rest of the panel, I'm sure. I know this is your final round with this case, so I won't give you anything specific to this case, but I'll just give you guys 2 things I thought both teams did really well, and 2 things I think you guys can work on as you move forward in your mock trial careers and hopefully your legal careers one day. So the 2 good things was, first of all, the technology was so good. We've come a long way in the Zoom world. I love the red boxes and the call outs. It was just very nice as a judge to see, and for you to, call my attention and call all of our attention exactly to what you wanted us to understand. That was great. Both sides did it great. I was having a great time. And I'll tell you, even in law school mock trial, I've seen people just like share their normal screens, and you see their thousands of emails at the top, and it's not as clean and crisp as what you guys had. So very good job. The second thing is you guys' I want to say like fearlessness with the rules of evidence. You guys were very confident. Sometimes your arguments were great. Sometimes your arguments, you guys just need more work and more, more instruction on like how to understand these rules of evidence. But I thought whoever's teaching you so far is doing a great job, because I thought you guys just made them and you made cogent arguments. And I thought you guys were like, I just really appreciated that you guys were willing to go for it and make the arguments and, come up against the opponent without, being afraid that maybe you're wrong. So I just really appreciated that. The 2 things to work on, one is kind of small and one is kind of big. The small thing is names. So I cannot keep track of all these people, especially the very first witness. I was struggling. And even the second witness, I was still trying to be like, okay, who is who? Some of that can be solved by, if you're on the prosecution, one name is just easy: defendant, defendant, defendant. So I noticed at one point the prosecution was referring to the defendant by his actual name. Then you went to the sensei. And then sometimes you would say defendant. I think just pick one and go with it. And that way I always know, okay, that's the guy on trial. And then that's just one name taken care of. And you can figure out what to do about the rest. But just be mindful about the fact that these names really well, but we don't. So just, figure out little ways to signify who you're talking about. That's not just random name. The other big thing is both sides need to be aware of what the other side's best arguments are going to be, and then say something about them a little bit earlier. So prosecution, you knew that the defense was going to say she did this on her own, like she had this big motive, and I didn't hear anything about it, not in your opening. And then your first witness testifies, and then they get up on cross and they're like, actually, like so-and-so was being bullied. There's this whole other motive. And I was like, whoa, why am I not hearing this from the prosecution? So if they're going to make that argument, make it in advance. Same thing with the defense. I didn't understand how the girl could get to the house without having the address. I didn't know where she got the address from, if not the defendant. Defense, I don't know what your explanation was. You guys just kind of like never brought that up, and maybe your strategy was just to ignore it and hope we forgot about it. But I kept thinking about it, and it didn't come up in closing. So maybe you didn't have an explanation, or maybe you just say that. I don't know, but make sure you know what the other side is going to say, because these were pretty straightforward cases. And then say something to the jury about it in advance, get ahead of the argument. Don't let the first time I'm hearing the bad thing come from the other team, because then I'm wondering why I didn't hear it from you. Yeah, that is it. Great job, you guys. Good luck to both teams. You guys are incredible. And thanks for letting me judge.
All right. The second person I saw was Sue. So you're up.
Yeah, I want to second that. Great job to both teams. I can see how you end up in the final round. I know you put a lot of work into it, and that was clear from the presentations that you did. I agree with everything that Regina said, and I don't want to, rehash anything she said. So a couple of other, one other good thing that I just wanted to comment on, and then another thing or two to work on. Good thing. I was also impressed with not only the tech, but the way that you used the tech. I thought that your use of exhibits and the way that you pointed out the important facts and what the implications were was really excellent on both teams' parts. It helped us to understand why you wanted us to see those exhibits and what it was that we should take away from the exhibit. So really nice job on that. The other thing, I guess, as far as something to work on for witnesses, I thought some of you were really good at deciding when to give an explanation on cross-examination, when a bit of explanation was warranted, but others fought a bit more than was necessary, you felt the need to explain kind of to every question, and that can make you just seem less credible after a period of time. So you just want to think about, is this something where some explanation is warranted because the question was a bit vague, or maybe it didn't quite hit on the thing accurately, or should I just say yes, and then the jury won't hear the answer as much. It won't have as great of an impact than if you choose to fight more. So I know the other judges have a lot of good things to say, and so I'll just stop with that. But really, congratulations to both teams. Outstanding job.
Travis, you're up.
Yes, again, don't want to echo too much, but if any of you guys are going to college next year and competing in AMDA, I would be very scared to see you on the circuit. You guys are all so amazing. Can't believe you're high schoolers, and you guys have such a bright future ahead of you in college, mock trial, and beyond, or whatever you choose to do. So I just have a few good things and a few things to work on. Kind of echoing what Regina said earlier about objections. I love objections. I'm such a nerd for objections. I love watching them, and I love evidence, but I specifically love objections in particular, because it's not just knowing the rules, it's how you talk about the rules and how confident you sound while talking about the rules. And I think we were put in there were a lot of sort of like moments in the trial where like that happened all the time. So even the best competitors were like, you're thrown off your feet by something that you weren't expecting, whether that's like the rule not being in the rule book, or if it's like, this is an expert and we forgot about like this specific rule that exists. And in those moments, it's very easy to like stress out and like freak out and like make that show both through your face and your like the way you're speaking. But you guys were so great in like staying poised and confident. And even when like the deck was stacked against you, you were still making really like strong arguments and saying them, most importantly, confidently. And that was a really great, amazing thing to see. Another amazing thing to see was signposting and looping, just like things like, I want to talk about this. I want to talk about that. There's two things I want you to focus on. Those things are so helpful for me that doesn't know anything about this case. And so I'm like, okay, these are the two things I have to focus on. Not going to think about anything else. So keep doing that. And looping was also great, just including like really bad statements that your witnesses were saying. Or I guess like good statements for your side, but perhaps bad for the other side. And the one thing to work on that I would say is this like kind of idea of like what it means to like be natural. I feel like sometimes it's kind of hard to really grasp exactly what that means. But I think that honestly, like the writing of your content could actually help a lot with things sounding more natural. So like both sides did this. I noticed it a lot of times. Sometimes your witness will say like kind of vague, vague answer. And then the attorney will go, well, what do you mean by vague answer? And like, it's just so like stock mock trialism. And like, also, I think is not really how people kind of converse with each other. Like if you said something vague, you probably explained what you meant a little bit after that. And so like really combing through your scripts and seeing like, would I actually like speak like this? Or would I actually like say this word? Would I use this vocabulary as this like character that I'm doing? All of those things can like help you like really make sure that you're seeing like a real breathing person, especially on Zoom, where like you kind of have to go the extra mile to really like kind of ground yourself and your humanity on screen. But again, like amazing job, all of you. Like you guys are amazing, and I wish you guys the best. And I'm so excited to hear the results.
Thank you, Butch. Sonali.
Great job, guys. I know we're standing between you and results, so I'll be quick. Just a couple of things that I noticed that were great on both sides. P attorneys, both of you guys had really great reactivity opener. For the opener, I noticed on the 403 objection, you were like ready to go with what he had said on direct that made you win that objection. And Faith, you did a similar thing on your cross when you said like you used what she had said about one test isn't enough. That kind of stuff is great. The more of that you can do, the better. And I think definitely at the college level, that's what separates like the great from the really good. So the more you can do of that, the better. For the defense attorneys, I think you both had really great rapport with the witnesses. And then also I noticed you guys did really well using sort of like the witness control techniques on cross when they talk too much or they didn't answer your question. That kind of stuff is always great. Keeps you in control, keeps you the star of the show. Especially on the plea deal point, I really noticed it there. And I thought that was a great point. Witnesses, both the sorry, I didn't write the names. The dad character on P and then the doctor on the defense both had just really natural seeming characters. I thought just came across really fresh and believable. Didn't seem very scripted, just like really kind of embodied the person all the way in a way that I think is rare to see in high school. So great job, both of you. For Emerson, I loved your very last answer to the direct in particular. It really sort of like helped me understand the whole case, your character, the whole theory. I think that was the point where I really like understood everything that was going on, and it was super well delivered. And for the defendant, my favorite part of your direct was your first few answers where you just seemed really enthusiastic, like, or just like a real person who like really loves, you know, what they're doing in their life. And that was really fun to watch. The one thing I would think about going forward is the openings. I think what Regina said about names, they were just a little confusing for me to follow as someone who like knew literally zero about the case, including like even the defendant's name. I had no idea. My test for this was to always just run my opening by someone in my life who did not do any mock trial and knew nothing. So my little brother has seen many a mock trial opening. So think about doing something like that and then asking like, did you know who everyone was? Did you know what was going on? Just those like basic sort of gut check, like, is the story coming across things? Because I think the team usually, the better you set yourself up for opening, like the better it goes for you the whole trial, and setting it up really well in opening helps you win points at every single stage of the trial when whatever you explained right at the beginning comes up later and I understand exactly what's going on, you know, before we get to the end. So great job. And I'm excited to see.
And last but not least, Sam.
Thanks, Toby. Excellent job, everyone. It was a fun round to watch. It was really enjoyable. The other benefit of being with such a prestigious panel is I don't have to, most of my comments would just be echoing what others have said, so I'll save folks. I think the big one for me was, in terms of positives, definitely confidence and rolling with the punches. And that's not just the objections. It also could be the particularly presumed tech issues. We had moments where witness froze or where on cross a couple times a question got dropped and you guys didn't let it bounce, you continued. That's 100% true for Zoom, but even in in-person trials, not everything goes according to plan. So the ability to just bounce with whatever gets thrown at you is tremendous and something you should hold on to. In terms of things to consider going forward, I think the biggest one, and this semi-echoes what others have said, is you guys have probably poured who knows how many hours into this case, and it definitely shows. But sometimes when you've read a case backwards and forwards, you start assuming everyone else in the world knows the case as well as you do. You know the specific facts, you know the players, you know the law. You don't. Sure, this is based off of Cobra Kai, so we have general sense, at least on my end, but I haven't read the fact pattern cover to cover. I don't know the players, I don't know the facts, I don't know what the specific arguments are going to be. So the big thing when it comes to putting a case together, and this is true for both P as well as defense, is assume your jury knows literally nothing. So the very first words from the P opening are the only things that are going to be written on the page in terms of my memory of this case. And same for defense. All I have is the P opening. So if there's something that's important for your argument that you don't think that the prosecution is going to cover, or something that you want to recharacterize, your D opening is 100% true for that, but it continues through the trial. The very first fact witness, again, if you assume nothing, you want your first witness to help set the scene. Same for defense. If you've got a defense, you want the first witness to help set everything. So I think you guys definitely have the talent. I think when it comes to like preparing a case going forward, you just assume that whatever your judges know, they know nothing. And if you prepare a case for that, it will help win over pretty much every judge. Because if they know the case, you're already going to get them. It's the ones who don't know, you want to make sure that they're up to speed so they know that you're right.
Thanks, Sam. And with that, I will turn you back over to our tournament hosts, who I understand have the results. Great job, everyone.
Thank you so much, Toby, and congratulations to all of our competitors. Really fantastic round. It was a pleasure to have you all. So if we could just give everyone a round of applause through our Zoom. Congratulations. So we do have our final results for our first ever, not just national final round, but international final round. We're very excited. This was a very close round, but I am extremely thrilled to announce our champions. For those of you in the final round, primary contacts, please send me your mailing address so that these trophies will be sent to you. But for our second annual Tournament of Champions, our grand champion will be Henrico High School. Congratulations to our prosecution team. To anyone watching, we appreciate you taking the time. Congratulations to our winners and our runner-ups. We hope to see you all again soon. And thank you so much again to all of our judges for taking the time as well. With that, we'll go ahead and sign off, but congrats one more time and enjoy your well-deserved win.
Thank you all so much.
Thank you guys.
And
Thank you so much.
Thank you so much.
Thank you guys. Thank you all. That was really enjoyable last